Pertama adalah administrasi akademik dan kemahasiswaan, administrasi umum SDM dan kepegawaian. Yang ketiga adalah administrasi bisnis dan keuangan. Kedepan adalah S2 dan S3 menuju kepada akreditasi internasional. Berikutnya di bidang mahasiswaan, di bidang akademik, di bidang riset juga akan berakselerasi tahap demi tahap menuju reputasi internasional. Warga Fakultas Hukum yang terdiri atas dosen, pendik, dan mahasiswa harus bersama-sama menuju kepada kejayaan dan kemuliaan Fakultas Hukum untuk menunjang visi misi kita menjadi Fakultas Hukum yang diakui baik di tingkat nasional maupun internasional. Mari bersama-sama kita wujudkan visi misi kita ke depan. Saya kira itu, saya tutup. Wallahul muwaffiq ila aqwamit thoriq. Assalamualaikum warahmatullahi wabarakatuh.
Change is real. It is there to guide us to be more mature. Founded in 1965, Universitas Negeri Semarang continues to transform into one of the nation's proud state universities. Like a tree, its roots penetrate deeply into the values and traditions of the nation. Its leaves are born to many great young talents. UNNES' vision is to become the world's reputable university, to be a pioneer of educational brilliance with a conservation perspective. This is the vision that guides us to carry out the three dharma of higher education: education, research, and community service. The change in institutional status from Badan Layanan Umum to Perguruan Tinggi Negeri Berbadan Hukum brought real changes in the academic, institutional, and cultural fields. The greater the autonomy, the more achievements are achieved. Leaner in organizational governance, more real in work and contribution. Perguruan Tinggi Negeri Berbadan Hukum is like a golden bridge. We are moving faster for achieving international reputations, educational excellence, and conservation inside.
Perubahan menjadi PTNBH membuat Universitas Negeri Semarang lebih fleksibel dalam memanfaatkan sumber daya yang ada, sehingga kita bisa berkontribusi optimal untuk bangsa dan negara tercinta.
9 faculties and 1 postgraduate school are bridges for young Indonesians to realize their dreams. Faculty of Education and Psychology, Faculty of Languages and Arts, Faculty of Social and Political Sciences, Faculty of Mathematics and Natural Sciences, Faculty of Engineering, Faculty of Sports Science, Faculty of Economics and Business, Faculty of Law, and the youngest, Faculty of Medicine. The accelerated development of facilities and infrastructure are signs of our passion to serve others. Healthy governance is a proof of sincere dedication from our heart. This is Universitas Negeri Semarang, home to young Indonesian talents who are ready to grow and contribute to the wider society.
Di UNNES, kami bukan hanya mempelajari ilmu pengetahuan, kami juga belajar tentang pengabdian, agar di kemudian hari kami bisa berkontribusi optimal untuk kemajuan Indonesia.
The network of cooperation on 5 continents has strengthened its work to become the pride of Indonesia's educational institutions. Creativity, values, and intention are reflected into the work. Knowledge and innovation are the foundation of its dedication. Universitas Negeri Semarang continues to transform. We welcome a new and brighter day of future. For the nation, for Indonesia, for human civilization.
Conservation is preservation of life on Earth, and that, above all else, is worth fighting for. Right here, in the middle of the northern coast of Java, Universitas Negeri Semarang had taken this fight seriously, working on to preserve our nature, our culture, and our very own humanity. Against the challenges of time, building up the younger generations, molding them to the brilliant future. Through education, we grow awareness and concern, preparing them for the sake of the stability of our hereafter on this blue planet we call home. Sir David Attenborough once in his broadcast said that the final chapter is ours to write. We already know what we need to do, therefore, what happens next remains up to us. With the vision of being an international reputed law faculty and gilded with conservation's values on our attributes, the Faculty of Law Universitas Negeri Semarang had continuously provided its pupils with the best amenity and environment for them to thrive and study. The determinations of service are among the faculty goals in nurturing the future of our nation with our commitment to prepare future legal experts qualified with broad insight, intelligent minds, resilient and reliable, as well as fair and prevailing character. With ceaseless advancements to offer, the Faculty of Law endeavor to provide the students on their needs for the progress and development of their studies. Students at the Faculty of Law also encouraged to broaden their insight by using technologies such as e-learnings, as well as using informations to update their awareness on global conditions and ignite their critical way of thinking. With a proficient experience in this field of legal research and education for 15 years, the Faculty of Law remained consistent to form the students' character development within the frame of Pancasila and Undang-Undang Dasar 1945. The Faculty of Law also created a balanced hub for students to fulfill their needs of physical and spiritual growth, habituating piety as the foundations of their daily life. Furthermore, cultivating tolerance to the diverse members within our academic community in line with the ideal value of integrations comprised by Pancasila and the Undang-Undang Dasar. The development of research and interpretations on legal studies are our main approach to enrich the students' knowledge. The students gain plethora of insights from the lectures and discussion sessions with our lecturers. With about 3,480 active undergraduate students, 320 active postgraduate students, and our recently opened doctorate program, the Faculty of Law offers an interactive space for the students to interchange and enhance their knowledge. Here, at the Faculty of Law, not only we develop soft skills of our students with theories and lectures, but we also provide them the skill and experience to act as legal practitioners, training them to be the best professionals in the coming of times. In the late 5 years, the Faculty of Law had witnesses an increase in the numbers of applicants. The Faculty of Law provides a testable and qualified educational standard accredited nationally by BAN-PT and internationally by AQAS. Also, the Faculty of Law is home to 2022 students' activity groups and organizations. Therein, the students gain a lot of experience of advocational skills, of diplomatic skills, leadership skills, and those and others to refine their quality in the future social life. From spiritual to sporting, there is an endless room for our students to develop their interests. And from these extracurriculars and organizational activities, the students also gain achievements that brings them the prestige and competence to be proud of. Hence, we are confident that the students in the Faculty of Law are more than just qualified, but also ready to participate in the continuity of our struggle, to uphold the justice in the name of humanity with all of the challenges thereof. The Faculty of Law also devoted to uphold the values of the Tridharma Perguruan Tinggi with the aforementioned responsibility of education. The Faculty of Law also carry out the duty of research through our 21 journals, of which some are accredited nationally and internationally. On our responsibility of dedications to the society, Faculty of Law also participate in the community service, which is one of the Merdeka Belajar Kampus Merdeka program that Universitas Negeri Semarang implemented, such as student exchange, field practice, humanitarian projects, entrepreneurship, and etc. To further cultivate these values, the Faculty of Law also provide 10 research and study centers, of which the students are able to elaborate their critical thinking about the law as it is and the multidimensional implications of it, and also to compare it to real-life conditions. Therewithal, we also accommodate 8 legal clinics, of which the students can accentuate their practical and professional abilities, whilst also performing communal service in the form of legal advocacy and advisory. In acquiring the visions to obtain international reputations, Faculty of Law Universitas Negeri Semarang had built collaborations and partnership with numerous law schools and universities around the world. Alongside to that, over various government and private institutes all over Indonesia. These collaborations not only add the connections of the faculty, but it also brings opportunities for the students to apply for exchange, internships, work practices, and resources for their future research. The Faculty of Law Universitas Negeri Semarang has committed to provide the best service when it came to terms of the progress and growth of academic developments of the students. The Board of Lecturers, administrative staffs, and the entire faculty officers are prepared to perform their best ministrations and assistance for the successions and continuance of their educations within our faculty. Sitting back to the quoted saying of Sir David Attenborough, that final chapter of whom we are the author refers to how do we take our actions on that what we need to do in terms of preserving the future of our humanity. Here, from the hilly region of Sekaran, we are confident in our preparations to hail the future laying ahead, united in our service to provide justice to mankind. The Faculty of Law, Universitas Negeri Semarang. Viva Justitia!
Assalamualaikum warahmatullahi wabarakatuh. Saya Ali Masyar Mursyid, Dekan Fakultas Hukum Universitas Negeri Semarang. Fakultas Hukum adalah fakultas yang masih muda. Namun demikian, prestasi-prestasi Fakultas Hukum tidak kalah dibanding dengan fakultas-fakultas hukum yang lain. Kita berakselerasi untuk menjadi fakultas yang bersanding dan bersaing dengan fakultas-fakultas hukum yang lain. Fakultas Hukum di bawah visi menjadi fakultas hukum bereputasi dunia, pelopor kecemerlangan pendidikan yang berwawasan konservasi. Memiliki 61 dosen, 19 doktor, 3 profesor, dan selebihnya adalah magister. Fakultas Hukum yang lahir tahun 2007, kita memiliki 3 prodi. Yang pertama adalah prodi S1 Ilmu Hukum, prodi S2 Magister Ilmu Hukum, dan lahir tahun 2023 ini yaitu program Doktor Ilmu Hukum. Dan di bawah S1 kita memiliki 3 konsentrasi, yaitu bagian pidana, bagian perdata dagang, dan bagian HTN-HAN. Fakultas Hukum yang masih muda juga memiliki berbagai macam keunggulan-keunggulan dan prestasi. Di antaranya adalah kita telah memiliki 21 jurnal. 2 jurnal diantaranya telah terindeks Scopus. Selain itu, dosen-dosen kita juga berprestasi di berbagai bidang, terserap dan bereputasi di tingkat nasional hingga mencapai internasional. Kita juga memiliki program PKPA yang juga telah diakui dan bisa menjadi satu keunggulan tersendiri dibanding dengan fakultas hukum yang lain. Di bawah dekan, kita memiliki 3 wakil dekan, yaitu wakil dekan 1 bidang akademik dan kemahasiswaan, wakil bidang 2 bidang perencanaan dan sumber daya, sedangkan bidang 3 adalah riset, bisnis, dan kerjasama. Dibantu dengan 28 tenaga kependidikan yang terbagi dalam 3 administrasi, yaitu yang pertama adalah administrasi akademik dan kemahasiswaan, administrasi umum SDM dan kepegawaian, yang ketiga adalah administrasi bisnis dan keuangan. Kedepan S2 dan S3 kita menuju kepada akreditasi internasional. Berikutnya di bidang mahasiswaan, di bidang akademik, di bidang riset juga akan berakselerasi tahap demi tahap menuju reputasi internasional. Warga Fakultas Hukum yang terdiri atas dosen, pendik, dan mahasiswa harus bersama-sama menuju kepada kejayaan dan kemuliaan Fakultas Hukum untuk menunjang visi misi kita menjadi Fakultas Hukum yang diakui baik di tingkat nasional maupun internasional. Mari bersama-sama kita wujudkan visi misi kita ke depan. Saya kira itu, saya tutup. Wallahul muwaffiq ila aqwamit thoriq. Assalamualaikum warahmatullahi wabarakatuh.
Conservation is preservation of life on Earth, and that, above all else, is worth fighting for. Right here, in the middle of the northern coast of Java.
Change is real. It is there to guide us to be more mature. Founded in 1965, Universitas Negeri Semarang continues to transform into one of the nation's proud state universities. Like a tree, its roots penetrate deeply into the values and traditions of the nation. Its leaves are born to many great young talents. UNNES's vision is to become the world's reputable university, to be a pioneer of educational brilliance with a conservation perspective. This is the vision that guides us to carry out the three dharma of higher education: education, research, and community service. The change in institutional status from Badan Layanan Umum to Perguruan Tinggi Negeri Berbadan Hukum brought real changes in the academic, institutional, and cultural fields. The greater the autonomy, the more achievements are achieved. Leaner in organizational governance, more real in work and contribution. Perguruan Tinggi Negeri Berbadan Hukum is like a golden bridge. We are moving faster for achieving international reputations, educational excellence, and conservation insight.
Perubahan menjadi PTNBH membuat Universitas Negeri Semarang lebih fleksibel dalam memanfaatkan sumber daya yang ada, sehingga kita bisa berkontribusi optimal untuk bangsa dan negara tercinta.
9 faculties and 1 postgraduate school are bridges for young Indonesians to realize their dreams. Faculty of Education and Psychology, Faculty of Languages and Arts, Faculty of Social and Political Sciences, Faculty of Mathematics and Natural Sciences, Faculty of Engineering, Faculty of Sports Science, Faculty of Economics and Business, Faculty of Law, and the youngest, Faculty of Medicine. The accelerated development of facilities and infrastructure are signs of our passion to serve others. Healthy governance is a proof of sincere dedication from our heart. This is Universitas Negeri Semarang, home to young Indonesian talents who are ready to grow and contribute to the wider society.
Di UNNES, kami bukan hanya mempelajari ilmu pengetahuan, kami juga belajar tentang pengabdian, agar di kemudian hari kami bisa berkontribusi optimal untuk kemajuan Indonesia.
The network of cooperation on 5 continents has strengthened its work to become the pride of Indonesia's educational institutions. Creativity, values, and intention are reflected into the work. Knowledge and innovation are the foundation of its dedication. Universitas Negeri Semarang continues to transform. We welcome a new and brighter day of future. For the nation, for Indonesia, for human civilization.
Conservation is preservation of life on Earth, and that, above all else, is worth fighting for. Right here, in the middle of the northern coast of Java, Universitas Negeri Semarang had taken this fight seriously, working on to preserve our nature, our culture, and our very own humanity. Against the challenges of time, building up the younger generations, molding them to the brilliant future. Through education, we grow awareness and concern, preparing them for the sake of the stability of our hereafter on this blue planet we call home. Sir David Attenborough once in his broadcast said that the final chapter is ours to write. We already know what we need to do, therefore, what happens next remains up to us. With the vision of being an international reputed law faculty and gilded with conservation's values on our attributes, the Faculty of Law Universitas Negeri Semarang had continued
This is Dina. Can you share my voice clearly?
I can. But I can also hear I can also hear my voice.
All right. Thank you so much, Professor Ildiko. Ladies and gentlemen, my respected guests and all participants in Zoom meeting today, the event of Global Classroom between Faculty of Law Universitas Negeri Semarang and Faculty of Law University of Cambridge will begin soon. The leaders and invited guests as well as the participants are expected to follow the activity carefully, and online participants are expected to turn on the camera and turn off the audio during the event. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan. Good morning, ladies and gentlemen. My name is Terus Kanita Lamsyah. It's a pleasure for me to be the master of ceremony on this very special occasion, Global Classroom between Faculty of Law Universitas Negeri Semarang and Faculty of Law University of Cambridge will with the theme Intellectual Property Policy and its implementation in European Union and in Indonesia. First of all, let's say thanks to God who has given us guidance, happiness, health, and mercy so we can attend and participate in this space without any obstacle. So before, I would like to welcome the Honorable Dean of Faculty of Law Universitas Negeri Semarang, Mr. Dr. Ali Masyar SHMH, the Honorable Olaf Vice Dean Faculty of Law, Mrs. Dr. Industri Utari SHMHUM, Mrs. Aprilani Rafita SHMKN, and Mr. Muhammad Azil Maskur SHMH, and the Honorable Olaf Dean Division of Faculty of Law, and also the Honorable Academic and Administration Staff. And also, I would like to welcome Professor Ildiko PhD as our speaker today from University of Cambridge, and Mrs. Tirawati PhD, and all of audience from Faculty of Law and also University of Cambridge. So on this special event, we have several agendas. The first agenda opening by Master of Ceremony. The second agenda seeing the National Anthem of Indonesia and Mars Faculty of Law Universitas Negeri Semarang. And the third agenda welcoming speech and by the Dean of Faculty of Law Universitas Negeri Semarang. And the fourth agenda, main section of this event, and the last agenda closing by Master of Ceremony. So well, ladies and gentlemen, let's begin to do first section by singing the National Anthem of Indonesia, Indonesia Raya, and Mars Faculty of Law Universitas Negeri Semarang. All the guests and audience, please rise.
Satukan langkah kita bersama, songsong hari depan nan jaya, emban tugas suci mulia, didik putra putri bangsa, Fakultas Hukum UNES nan jaya, bertekad membangun bangsa, siapkan para sarjana hukum bermutu, takwa padanya berjiwa Pancasila, dengan berdasar pada Pancasila dan Undang-Undang Dasar 45 serta Tridharma perguruan tinggi sebagai dasar pengabdiannya. Majulah fakultas kita, jayalah selamanya, memelihara dan mengembangkan ilmu hukum yang berkeadaban. Fakultas Hukum UNES Semarang siap sedia sosok kemajuan zaman.
To the next agenda, welcoming speech and open the global classroom officially by the Dean of Faculty of Law, Universitas Negeri Semarang. This speech will be delivered by Mr. Dr. Ali Madyan, SHM. For Mr. Ali, the time is yours.
Okay, thank you, Feroz. The honorable invited speakers, Professor Idiko Barta from Faculty of Law and Political Science, University of Debrecen, Hungary. Good morning, Professor Idiko.
Good morning. Good morning.
What time there? No,
8 o'clock. 8 o'clock morning.
8 o'clock. Still morning, yeah.
Yes.
Yes, okay. The Honorable Bu Associate Professor Bu Irawati from Faculty of Law, Universitas Negeri Semarang. Selamat siang, Bu Ira.
Selamat siang, Pak Dekan.
Okay. The Honorable Vice Deans of the Faculty of Law, Universitas Negeri Semarang, the lecturer and students of the Faculty of Law, Universitas Negeri Semarang. Okay, I'm sorry. And Universitas Faculty of Law and Political Science, University of Debrecen, Hungary. The Honorable Global Classroom participant from Hungary, Malaysia, South Africa, India, and all around the world. Assalamualaikum warahmatullahi wabarakatuh. Good morning, good afternoon, ladies and gentlemen. Warm greeting to all of you. I am honored to be given this opportunity to deliver this opening speech. Please allow me to express our appreciation for your availability to attend and join this academic event. I, on behalf of our faculty, welcome you all to the Global Classroom in collaboration with the Faculty of Law and Political Science, University of Debrecen, Hungary. Global Classroom is an academic event to support universities' case performance indicator, or in Indonesia we will known with IKU, Indikator Kinerja Utama. This event is aimed as a medium for law students from all around the world to learn more about intellectual property policy and its implementation in the European Union and Indonesia. Hopefully, this event will bring benefits not only for us, but also for legal development. Thank you for your attention, and without any further ado, let us officially begin this event. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much, Mr. Ali, for the welcoming speech and open the global classroom officially. So, well, ladies and gentlemen, the next is photo session. Please, all the audience, turn on the camera because I will take a screenshot for photo group session. Right. Participant, please turn on the camera. So I will take the photo in 3, 2, 1. Right, once again. 3, 2, 1. Smile. All right, thank you so much. So, well, ladies and gentlemen, let's move to the next agenda. And we come to the main event of Global Classroom between Faculty of Law, Universitas Negeri Semarang, and Faculty of Law, University of Debrecen, with the theme Intellectual Property Policy and its implementation in European Union and in Indonesia, which will be guided by our moderator. She is Mrs. Dina Sylvia Putri, LLM. So before, I would like to tell us the curriculum vitae of Mrs. Dina first. All right, ladies and gentlemen, our moderator today, Mrs. Dina Sylvia Putri, LLM, started her teaching career at Universitas Negeri Semarang in 2023 as the Civil Safety Division, Faculty of Law. And she took her undergraduate degree and her Master of Notary at Faculty of Law, Universitas Airlangga, Surabaya. And then she completed her master's degree in law at Tilburg University, Netherlands. So without any further ado, Mrs. Dina, the floor is yours.
Thank you very much for MC, for Fairuz. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon and good morning, everyone. I would like to welcome all of the participants here. It is such an honor for me to meet all of you from all around the world, great people in this event. So my name is Dina, and I will be the moderator for Global Classroom 2023, Intellectual Property Policy and its Implementation in European Union and in Indonesia, held by Faculty of Law, Universitas Negeri Semarang, in collaboration with Faculty of Law and Political Science, University of Debrecen, with the speaker, Professor Ildiko Berta, PhD from Faculty of Law and Political Science, University of Debrecen, and Ms. Irawati, PhD from Faculty of Law, Universitas Negeri Semarang. Before we start the session, I would like to read the code of conduct of today's event. First, please turn on your camera and use the virtual background as already mentioned by the MC, and make sure to turn off your mic except when it is your time to speak. Second, the speakers will deliver their session first, and the question and answer will be after the two speaker sessions. And third, everyone who would like to ask questions, please write your question and for which speaker on the chat room, or later raise your hand on the question and answer session, and I will pick the question. Okay, so I would like to read the CV of our first speaker. So for Professor Ildiko Berta from University of So would like to welcome Professor Ildiko Berta from University of Debrecen, Hungary. She is currently the head of Department for European Law and International Law, University of Debrecen, and she finished her doctoral degree in 2010 in Legal of Political Science from University of Miskolc, and currently she already just being the professor. So without any further ado, I would like to welcome, please give warm welcome to Professor Ildiko to deliver her presentation regarding the intellectual property in European Union. Professor Ildiko, the time is yours.
Thank you very much. Welcome. First of all, I would like to express my appreciate and great thanks to this invitation. It is a very big honor for me to be here and to hold this presentation to you. And let me share my slides. First, I would like to ask you, can you see my slides? And please let me try the slideshow function. Does it moving? Can you see the moving of the slides, or only one slide?
Currently, it's still one slide, like
Still
the
one
unified
slide.
pattern court. Yes.
So do you mind if I do it without slideshow function?
I think it's okay.
It's okay.
We can still read it perfectly. Yeah.
Okay. Thank you. Because sometimes I cannot calculate in advance when, but sometimes I have this problem with my
Or if you don't mind,
function.
maybe we can try to help you to do the share screen. Or I mean, this is already perfect. But if you want, we can also help you to do the share screen.
Okay.
You can set it in the chat room or to me directly, and I will help you to do the share screen.
So shall I check the chat?
Or actually, it's like up to you, like whatever you feel convenient with. I mean, for this one, we actually can see the screen.
Mm-hmm.
However, it's not as big as it should be, but we can still read it perfectly. So if you just want to continue, then it's up to you.
Okay, I would like to ask you what you prefer to begin with, and maybe we can correct it during the lecture, because I try to check the chats during the lecture. Or so I can do the lecture and then checking the chat function whether I can have a message with the advice how to correct it. What do you think?
I think it's okay. Then you can just continue first.
Okay. So thank you very much. I consulted in advance with my colleague Ashur Ibrahim Noor that what could be good to address during this session, because of the fact that the intellectual property right is a very large topic. This set of rights and the related regulations to the European Union, and we agreed in holding a brief overview about the main principles and rules and questions to address by you intellectual property rights. And during this overview, I will point to few interesting issue with case law example, because in the European Union legal system, it is very important the role of the European Court of Justice and the cases of the European Court of Justice, not only because these are very interesting leading cases, but also because these are not only interpretation of law, but also development of European law, despite the fact that it is not a recognized precedent law like in common law system. The role of the case law is very important here. So let's see an overview that I would like to question. I would like to start with the question that why it is important to regulate by means of EU law instruments these intellectual property rights, because when the European communities have been founded, the question of intellectual property rights was not a question of the integration. Integration was focused rather on core economic issues like agriculture, competition in the strict sense, transport and so on, but not intellectual property rights. But as the integration went ahead, new problems, legal problems have been raised, and this illustrated that the regulation of intellectual property rights is very, very important also for the point of view of integration. And then the technical development also confirmed that it is almost impossible to operate integration, economic integration without dealing with intellectual property rights. And that point I would like to I would like to show you that what are the main dimensions of regulating intellectual property rights in the European Union. I would do two main groups: the international dimension and the external dimension. What does it mean, this internal dimension in this context? It means simply that the intellectual property rights, these very often are in conflict between the main principles of European internal market law, especially the so-called four fundamental economic freedoms of the internal market and the EU competition law provisions. There are many conflicts of that, and this is, I would say that this is the main reason to solve this conflict, the conflict between the interest of integration, economic freedom, liberalization on the one hand, and the right to protect intellectual properties on the other hand. And what about the external dimension? It mainly constituted by international agreements concluded between European Union member states on the one side, and third countries and international organizations on the other side. So this international dimension is very much about complying with external standards of intellectual property rights protection. Let's see more about this internal dimension. This first segment of internal dimension is about the possible conflict between the economic freedoms of EU internal markets and intellectual property rights. Why there is a conflict? This question can be raised first. The conflict mainly arises from the fact that the intellectual property rights of their nature are exclusive, exclusionary, even monopolistic, and this nature often conflicts with the principle of liberalization, not creating monopolistic situation in the market, not isolating national markets, and so on. So these are often in conflict. I will also highlight it by example. And this, as you can see, this for economic freedom in the EU internal market means the free movement of goods, persons, services, and capital. And from these four economic freedoms, the free movement of goods and free movement of services are mainly concerned. And the question is that what are the main instruments provided by EU law to solve these conflicts? I would make two groups. One is the so-called deregulation, which simply means prohibition in the founding treaties of the European Union. In other words, these called as deregulative provisions, which means that it is prohibited to do quantitative restrictions, prohibited to discriminate between according to in terms of the origin of goods, or to apply discriminative taxation is also prohibited, and so on. And the second way of solving this conflict is the regulation. What does it mean? In other words, we can call it as harmonization of intellectual property rights of the member states in order to make them more unique, more approximated, more harmonized, and therefore to try to find solution by providing quite unique regulation of the most important aspects of intellectual property rights. And let's see one example for that deregulation issue. So to the question that what kind of conflict can be raised between the provisions of EU law addressing deregulation and the intellectual property rights. Here you can see, for example, this provision, Article 34 from the main funding treaty of the European Union, which simply means, simply says that quantitative restrictions and those restrictions which have the equivalent effect to quantitative restrictions shall be prohibited between member states. It is a quite broad category, these measures having equivalent effect to quantitative restrictions, and it also includes provisions in member states' laws relating to the country of origin of goods. So it means that in the European Union law, for example, French law, which says that all the goods marketed in French must be labeled by a country of origin label, such a rule itself can be obstacle to the EU internal market. And as a counterpart to this prohibition, we can also see exemption also in the main treaty article, which, as you can see here, expressly said that there are several public reasons for making exemptions to the main rules, and one of that is the protection of industrial and commercial property. So it is the so-called intellectual property protection clause within that. And there are many legal cases conflict about the relation between these two articles. And there is a very big debate about the fact that which needs to be interpreted broader, and which, so the major order exemption, or which in a more restrictive way. And what is important here to establish that this very generally formulating of this deregulation provision and also the exemption leads to many many versions of interpretation, and which is also questionable from the point of view of legal certainty. Therefore, we can say that it is much better that if you can harmonize, if you can regulate, if you don't only have these deregulation provisions. And so this regulation means approximating laws of the EU member states, which means more than abolishing obstacles as in the previously mentioned case of deregulation. I would say that in a strict sense, this is called this. So the result of the regulation by means of directives of the European Union. This is what called in a strict sense as the core of the intellectual property regulation of the European Union. And here you can see set out the main groups within the main areas of regulating intellectual property rights by the European Union law. As you can see, the first and maybe the most important most complex group is the copyright and related rights, then patent and utility models, design, trademarks, including own EU trademarks, geographical indication, and other types of intellectual property rights, which do not belong to the former groups. Let's see first copyright and related rights. I would say that really this is the most complex issues which may challenge the internal market principles of the European Union in various ways. And from the early 90s, this field is developing within the European Union. By from the 90s, because of the growing number of copyright infringements, also due to the technical development like using internet and so on. And it can also be connected to the enlargement of the European Union, that with the territorial enlargement, the number of cross-border trade conflict in terms of free movement of goods and services is also growing. There was also an important point to address the problem of piracy. For example, and that other conflicts, and it is also important that this external dimension very much connected to the external side as well, because if the internal regulation of the European Union in intellectual property rights can be competitive. Opera is good. It is then also makes the European Union a stronger partner. Just one question from my side that I have seen in the chat question. Is it okay if I return to this question at the end of the presentation?
Yeah, if you want to answer after the session, it is okay, but there will be also like the question and answer session, which will be after the second speaker. So
okay,
if after your session you want to answer the question, that is also okay. But if you want to answer during the question and answer session, that is also fine.
Okay. I just asked it for organizational reasons. Okay, thank you. So here you can see the set of directives which are the main results of the EU legislation in the field of copyright and related rights. I would like to show you example related case law example related to resale rights directive. Here you can see it is a case relating to Salvador Dali, the painter, and his conflict with the EU internal markets, or his case with the internal market law, because his conflict was not with the EU internal market law, but with the French law. But with the French law was in conflict with the internal market law. So what does it mean, this resale rights? Here, this resale right can also show that the regulation of the EU international intellectual property often originates from external sources. So here, in case of the regulation of resale rights, it also has the origin in the Berne Convention from the middle of the last century. So it is also important here to emphasize that all of these intellectual property directives of the European Union aims at approximating the member states' law as much as possible, but they always leave certain degree of discretion in regulation for the member states. This is also the case in our resale right directive, because here you can see that so it left some certain degree of freedom for the member states. According to the French law, that time, so which means at the time of that case, which was so the case was initiated in 2008. So the French law said very strictly that following the death of the author of work, the beneficiary of the resale rights are limited to the author heirs of law. So it means that the French law excluded any testamentary solution. The artist died in 1989, and he left will and left all his intellectual property rights to the Spanish state, since he had some tension with the family members. And accordance with the French law, in accordance with this very strict, very obvious rule, the legatees wanted to collect the intellectual property rights of Dali's works, and the dispute has arisen between the family members and the Spanish society, which represented the Spanish state, which was entitled to collect the intellectual property rights of Delhi in accordance with the will of the artist. What was the legal conflict here? The legal conflict here was that whether the French law has such a degree of freedom to provide this very strict rule, because of the fact that it was deterrence from the main rule of the EU directive, because the EU directive said that so the principle of the EU directive was that it is the freedom of the artist to decide who will be benefited from the resale rights of his or her intellectual property after his or her death. So this was the main principle of EU law, but it left to the member states some degree of freedom in defining the categories of persons who can be considered as the exclusively entitled for these intellectual property rights. In this case, the solution was that it is the freedom of the member states, so the previous member states are not precluded by doing such type of regulation. So it was according to the directive, the freedom of France to regulate intellectual property rights, heritage this way. And this example only wanted to exemplify that it is still the case with many aspects of intellectual property rights, that the European Union try to approximate the legal provisions, but also try to leave freedom for them. Here are the many other field that I don't want to explain in details. The main groups are already mentioned before, and I'm so I only want to mention here that the technical development also made it necessary to modify these directives quite frequently. And one of these example is the question of what to do with used software, whether they are goods or services in accordance to the relevant provisions of the European law. And the Court of Justice answer was that the owner of copyright in software cannot prevent a perpetual license who has downloaded the software from the internet from selling his used license. So it was a very important interpretation of the rights of extortion, and it also illustrated that the technical possibility of downloading used software and then the marketing of used software can also cause many conflict with intellectual property rights, because this reselling used software is I would say is in line with the main principle of the internal market, but not with the main principle of intellectual property rights. So it is also very important to mention so the EU competition law is the second internal dimension. So it means that the European Union law is based on the free competition, free and fair competition, which means that there is a need to regulate and restrict competition on the internal market, but only in the necessary degree. And it also means that the exclusive rights, which is the part of intellectual property rights, can be often conflict with one very important prohibition of EU competition law, which is that any abuse by one or more undertaking of dominant position within the internal market is incompatible with the internal market. So it means that if there is a very big market player who has a very large market share on a certain product market, more than 50 or 60%. In this case, for that market player must be very careful in using intellectual property right and in invoking intellectual property rights against the main provisions of EU competition law, because such market player can often be the subject to claims that it uses the intellectual property rights to make abuse on the EU internal market. So, for example, it can be the case that if you if you have the know-how of a production of a medicine or of a chemical which is the ingredient for other important medical product. In this case, you must be very careful to say that the production of this medicine is my intellectual property rights, and I will select who can use it and who not. So this is the intellectual property and competition law conflict aspect. Regarding the external dimension, I only want to say, because I don't want to go beyond my time frame, that the external dimension means that the European Union not only aims at harmonizing the domestic laws of the member states, but also try to follow the main international standards, which means on the one hand that the origin of the most important principles is the before mentioned directives have the origin from the main intellectual property rights conventions, And what is also important, that this harmonization also for the competitiveness for the European Union in its external trade policy. One which is important to say, that now the intellectual property rights and regulation of intellectual property rights is part of the EU external external trade policy, in EU law term common commercial policy. What does it mean? That now the European Union gained an exclusive competence to conclude treaties, external international agreements with non-EU states and international organization. So it's a very important development in the development of European Union law. And what is also very important to emphasize, that it can make a very complex jurisdictional conflict when under an international agreement concluded by the EU or in which the EU participates is applicable for a legal dispute between market player from non-EU country and one from an EU member state. And one of the aims for solving that reason was to establish a common unified patent court. And the agreement of establishing that court has been signed in 2013, but this agreement, on the basis of that the patent court could operate, is still not in force because of lacking ratification from all the member states. So very briefly, that is what I wanted to tell you today in the framework of that lecture. And of course, I will be very happy to answer all of your questions. I also seen the questions on the chat surface, so I didn't forget them, and I decided to answer this rather after the two lectures and not right now as a part of that. So thank you very much for your attendance.
Okay, so thank you very much, Professor Ildiko. So you just mentioned that you would like to answer the questions directly now?
No,
later, right?
Later,
Yeah,
so
okay,
after
okay,
the
I just
two
want to
lecture,
make
after
sure.
two.
Thank you
After the
very
second
much.
lecture, yes.
Okay, so thank you very much, Professor Ildiko, for the eye-opening session. We now can learn that there are intellectual property right in European Union can be seen from internal and external dimension, and there are a lot of challenges in the application. One of them is the difference between competition law in European Union and also the application of the intellectual property regulations. And the case from Salvador Dali is also really interesting. Okay, so thank you very much for your presentation, Professor Ildiko. Now I would like to continue with our second speaker. So I would like to read the CV of our second speaker first. So I would like to introduce our second speaker, Ms. Irawati, PhD. She is currently the lecturer at Faculty of Law, Universitas Negeri Semarang. She finished her doctoral degree in University of Canberra, Australia in 2015. Her areas of interest is intellectual property right and also private law. And she started her teaching career in 2004 and currently are the lecturer at Universitas Negeri Semarang. So without any further ado, please give warm welcome to Ms. Irawati. Ms. Irawati, time is yours.
All right. Thank you so much, Miss Dina, as our moderator of today. Please allow me to greet Professor Ildiko first. Professor, thank you so much for your very interesting and comprehensive lecture. And please allow me to congratulate you on your full professorship.
Thank you very much. Thank you.
So good morning to you and to ladies and gentlemen probably from Europe, and good afternoon, ladies and gentlemen from Indonesia and neighboring countries. The Honorable the Dean of Faculty of Law and the Vice Deans and all the participants, and I would like to thank to the committee for giving me this opportunity. It is an honor for me to be able to have a discussion with you all today. So, Assalamualaikum, selamat siang. Bismillahirrahmanirrahim. Miss Dina, can I share screen? Yeah. Can you see my, okay, yeah. So for my session, I will talk about intellectual property policy and its implementation in Indonesia. So these are the contents of my presentation. I would like to start by looking at the IPs in international dimension in a glance. Not will go very deep, but only the phases of the protection of IPs. And then I will look for how IP protections in Indonesia started, and then the pro-con of IP regime in Indonesia. As you may already know, that we probably almost, not almost, very time to time we hear that the intellectual property protection does not come from Indonesia side or from it comes from the Western. So there were pro-cons on IP regime in Indonesia. And then the last one before the conclusion, I will discuss about the IP regime in Indonesia today. So I will start with the three phases on protecting IP. Here, I quote the perspective of Professor Peter Brahos. He stated that roughly, actually, there are three phases on IP protection. The first period, considered as the territorial period, is essentially characterized by an absence of international protections. There were a lot of free riding at that time. And the second period, it was known as the international period. This period begins in Europe toward the end of the 19th century, with some countries agreeing to the formation of the Paris Convention for the protection of industrial property. It was in 1883 and known as the Paris Convention. And 3 years after that, there was the Berne Convention. For the convention talk about the protection of literary and artistic works. And the last period, it is known as the global period. So this period has its origin in the linkage that the USA met between trade and intellectual property in the 1980s. And this linkage leads to the TRIPS agreement. So the TRIPS agreement is binding on all members of the World Trade Organization. And then here, I would like to say that the TRIPS agreement, which came into effect on the 1st January 1995, is today known as the most comprehensive multilateral agreement on intellectual property. In this agreement, there are three main features. The first one is it established the standards respect to the main areas of intellectual property covered by the TRIPS agreement. And the second one established about the enforcement, which is set provisions deals with domestic procedures and remedies for the enforcement of intellectual property rights. And the third one, it established this dispute settlement. So this agreement makes disputes between WTO members about the respect of the TRIPS obligations subject to the WTO's dispute settlement procedures. Now, even though I haven't discussed about the regulations in Indonesia yet, however, I would like to mention that Indonesia has fulfilled these three main features. And actually, there are some IPs established in TRIPS. As Professor Ildiko stated before, copyrights and related rights, trademark, geographical indication, patents, layout designs of integrated circuits, and protection of undisclosed information. Until today, Indonesia has had regulations on each of these IP type. So here I would like to show that in international level, these two organizations administer IPs worldwide. So in 1995, WIPO and WTO established a cooperation agreement. So the WIPO becomes an observer to the TRIPS Council, which is WTO, and it's vice versa. So here I will start to talk about the IP protections in Indonesia from time to time. I would like to deliver the discussion by stating that the protections of IP in Indonesia can be divided into three eras. The first one is the colonial era, and then after Indonesian Independence Day, but before GATT or WTO agreements, and then after the GATT WTO agreement. Before I will discuss further, I will try to say something about where does IP lie in the law constellation in Indonesia. So I will deliver this by saying what Professor Oke Saidin, one of the prominent professor in intellectual property in Indonesia, here I apologize if it's still Indonesia, bahasa Indonesia, but I will try to give a brief explanation about this. So according to Professor Oke Saidin, intellectual property is actually lies in civil law or private law dimension, and then since the civil law or private law dimension consists of 4 dimensions about the subjects, and then the property law, and it also including the agreement law, and then the inheritance law. It's about like one of the ways of the IP transfer. But I would like to focus on the property law, and part of the property law is talk about laws on goods. And then the IP, as you may already know, falls to the intangible assets or property. So here is the law constellation of intellectual property in Indonesian law. So now I will talk about the 3 phases of IP's protection in Indonesia. So I will talk about the first era, that is the colonial era. So here I will mention about the period when Indonesia under the Dutch. So I can divide this into 2. The first one is that the Dutch represented Indonesia. It was under name Netherlands East Indies, of course, since they still colonized Indonesia, and it became member of Paris Convention for the Protection of Industrial Properties in 1888 and Berne Convention for the Protection of Literary and Artistic Works since 1940. And after that, there were 3 IP laws enforced in Indonesia. Now we call Indonesia trademark law, patent law, and copyright law. What happened after the Dutch left Indonesia? Indonesia was under the Japanese, and IP laws which left by the Dutch were still enforced. And then, oh yeah, I'm sorry, I forgot to mention that when Indonesia was still under the Dutch, other than these 3 IP laws enforced in Indonesia, there are also stipulation on trade secrets, which stipulated under the criminal code. And then here I will start to discuss about what happened after the Independence Day, but before got WTO agreement. So based on the Constitution of the Republic of Indonesia, all regulations which were effective left by the Dutch still enforced, as long as do not against with the Constitution. So therefore, the copyright and trademark laws were still enforced, but it's not what happened with the patent law. Why? Because the law of patent law, there is a stipulation which stated that the filing of registration for patent addressed to Patent Office in Batavia, Jakarta. it's not problem with this, but the problem falls for the checking, because the checking conducted in Octrooiraad in Netherlands. So as Indonesia has independent, this stipulation regarding the checking mechanism, of course, did not a proper mechanism anymore. And then after some years passed by, after 1945, in 1961, the government of Indonesia established some regulations on IPs, such as for patent. However, for patent, there are two regulations. These regulations differentiate about the regulation between the national patent filing and the international patent filing. And then at the same years, the government of Indonesia also established the law number 21 concerning enterprises and trademark. It is known as trademark law actually, and the trademark law became effective on 11 November 1961. I would like to add, in Indonesia, 11 November acknowledged as National IP Day in Indonesia. It's in regards with this matter. So after that, in 1979, Indonesia ratified the Paris Convention. And then in 1982, the government of Indonesia validated the law number 6/1982 concerning copyrights, which replaced the law established by the Dutch. So it took many years for Indonesia to establish its own law. And after that, in 1986, the government of Indonesia established a special team to establish policy in intellectual properties. So the team is actually drafted legislation in the field of intellectual property rights and also socializing the IPR system among relevant government agencies and also law enforcement officers and the wider community. This team, known as Team Kepres, or Presidential Decree 34, as it stipulated in Presidential Decree number 34, 1986. And then a year after that, the government of Indonesia amended copyright law. And a year after that, in 1988, the government established the Directorate of Copyright, Patent and Mark. After that, the government of Indonesia has amended patent, copyrights, and trademark laws to establish a more effective protection system. And in 1994, the government of Indonesia signed the final acts of Uruguay round, which included TRIPS agreement. In the same year, the government of Indonesia ratified the TRIPS agreement through the law number 7, year 1994. Before I will discuss about how Indonesia protects the IP today after the WTO agreements or TRIPS agreements, I would like to talk about the pro-con of IP regime in Indonesia. So the probably can be stated fundamental thought of Indonesian society is that Indonesia is a communal society. So IP protection considered does not align with Indonesia's value. However, since the Indonesia has signed the agreement, therefore Indonesia bends, of course, to the agreement. We must consider the Pacta Sunt Servanda principle. However, I found an interesting fact with the state that IP come from Western. So here I found in West Sumatra, there is a tradition called Marosok. It is a tradition on bargaining between co-seller and potential buyer. Negotiation on price is conducted secretly under sarong. Sarong is a fabric wears mainly by men by using some sort of method. This tradition considered as trade secret. So I will move to how Indonesia considers IPs today after the GATT or WTO/WTO agreement. So actually, what I will discuss is in line with the policy established by the government of Indonesia. So Indonesia today there are some advantages of intellectual property actually. The first one is the protection of IPs could protect nation assets. It could be nation icon and branding because it considers assist develop and sustain economic growth. In this point, local government should take part also to identify and protect communal intellectual property such as geographical indication. The second one, Indonesia believe that the usage of IPs in business, such as by micro, small, medium enterprises, and then research and development, of course, including in education and in economy area, since it is believed that it could boost the country's economy. Here, I would like to share that IPs have been holding very important state for Indonesia based on the research conducted by the Institute for Development of Economic and Finance. Every 1% of the number of patent increase, it impacted to 0.06% in 2017. Furthermore, in comparison, in 2018, the patent increase contribution to Indonesia revenue 1.69%, while in investment actually only 1.64%. And then it's still a hot topic until today in Indonesia that the government tried to implement intellectual property as collateral. So it is stipulated in government regulation number 24 year 2022. However, we still at the stage to establish the system. We are at the moment trying to prepare the such as valuation system and the human resources to become IP valuator. And then the IP regime in Indonesia today, I would like to look at it by differentiate into 3 categories. So from the substance, I will talk about it later on, next slide. And then the structure. So for the structure, we have institution authorized to administer IP, which is called IP Directorate General under the Minister of Law and Human Rights. And then the institution of law enforcement on IP, we have courts, business court and district court, but the district court only for trade secrets cases. And then we have IP Directorate General also for the law enforcement. And then we have arbitration and alternative dispute resolution. And also we have IP consultant also in Indonesia. And for the last one, trying to picture about the culture in Indonesia, the government of Indonesia has been trying, I can say probably quite hard, very hard, to establish the culture on IP through educating society conducted by the government officials such as IP Directorate General and relevant ministries, and of course included academics. And then this is the substance of regulation on IPs in Indonesia today. We have these 8 IP types regulations, and we also have another regulation regarding to exercise the exclusive right. Agreement on IP is excluded as stated in the law number 5, 1999. So here I would like to only some points that I would like to talk, that the rights of IPs in all the regulations of Indonesia, IPs Indonesia could be transferred through some sort of ways such as inheritance or by selling. And regarding with the trademark, Indonesia has been Madrid Protocol members, so it is possible to register trademark not only for national level but also for international level with the IP Office of Indonesia. And then yeah, I think I will go on to the another slides. Here I will only show you about the definitions of each of IPs. It's actually only give some sort of understanding about the definition. So like the copyrights, it is an exclusive rights which is arise automatically based on declarative principles. It does not have to be registered to the IP Office of Indonesia. While in patent, we have simple patent, the protection is for 10 years, and for the regular patent, the protection for 20 years. And for the marks, I found that in WIPO, it's already stated that marks also protect some sort of forms that has not been included in Indonesian regulation yet. That is perfume. The scent can be registered under the trademark. And then we also have geographical indications, trade secrets, and integrated circuits, layout design. And the newest, probably I can say that the protection of communal intellectual property, which is owned by communal and have permanent economic value, upholding the national moral, social, and cultural values. One of the example is like traditional knowledge. However, I also found that there are still shortcomings from the IP regime of Indonesia today. So here I write 2 points. The first one is, even though the Directorate General of IPs has been tried to establish easier registration system, for example, online and more economic fees for micro, small, medium enterprises and institutions, nevertheless, the number of applications for registration needed to be increased. And the second one, the mindset of many people of Indonesia, including entrepreneurs, who still thinks that it is not easy to register their IPs. So we come to the last part, the conclusion. So the protection of IPs in Indonesia can be divided into 3 phases. And then although until today, the IP regime in Indonesia has not well established and more advanced yet, compared to what happened in many other countries, the establishment of regulation aligned with GATT has shown that Indonesia is a country bound to the Pacta Sunt Servanda. So thank you so much for listening for my presentation. Bu Dina, time is yours.
Thank you very much, Ibu Ira, for the really insightful session. We know that from your presentation, there are 3 phases on protecting IPs, from the territorial period, international period, and global period. And in Indonesia itself, there is also 3 periods of IP protection, from colonial era, before the GATT, WTO, and after the agreement itself. Okay, so thank you very much once again, Ibu Ira, for the session. So now I will open the question and answer session. So for everyone, if you have any questions, you are welcome to write them down on the chat room, or you can raise your hand and we will point you out. So currently there are already several questions to Professor Ildiko. I will read the first question from Mr. Asrul from University of Debrecen. Professor Ildiko, could you please explain the impact of free movement goods and services for IPR holders in EU? Should they re-register their IPR to another EU member's jurisdiction? Maybe I can read the question one by one and then you answer the question. It will be more convenient, right, Professor?
Okay. In this case, the situation is that there is no need for registration, but not only because of the fact that the member states are the members of the European Union, but it is also rising from the Berne Convention. So there are also other countries which are not members of the European Union, but members of the Berne Convention, which may be benefited from that freedom. So it means that those who are the members of the Berne Convention, the market players or the intellectual property holders from that countries don't need to register the intellectual property rights in other member states.
Well, thank you very much for the answer, Professor. So I will continue to the next question from Ms. Ayu Indrayati, or if Ms. Ayu wants to directly ask the question, I think no. Okay, so I will read the question. I was wondering if copyright registration rates are the same in the EU?
So in this case, it's interesting because the member states have freedom for a different regulation in their own legislation, and they can also differentiate between the type of copyrights. it is also so they have freedom to define it differently. When it comes to, for example, to not copyright but to trademark, in this case there is a common regulation because there is a so-called EU trademark. Someone, an intellectual property holder, wants to use the EU trademark in an electronic form or as a label. In this case, they need to comply with the common trademark price determination. But in other circumstances, member states have the freedom in that.
Once again, thank you very much for the answer. So maybe Mr. Rizky, since you raised your hand, do you want to directly speak through the mic, or yeah, I think you can just ask directly to the speakers. Rizky Agung, Mr. Rizky Agung.
My voice coming in?
Yeah, we can hear you. No, it's currently,
Okay.
Okay.
Yes, I want to give the question to Dr. Irawati and Prof. Barta. We now in the disruption era, and one of the characteristics of disruption era is developing of social media as the business field. My question is, how does intellectual property regulation or UK if legal violation of copyright in social media? Thank you. Sorry, my English.
Okay. There's actually a bit of glitch in your question, but however, since you already write in the chat room, so the question for both Ms. Ira and also Prof. Ildiko, currently we are in like the developing of social media as business field. So how can the intellectual property regulation in both Indonesia and European Union give legal certainty or legal protection to content creator and reduce the violation of copyright in social media? Thank you for the question, Mr. Rizky. So maybe we can start from Ms. Ira first, maybe.
Sorry, I'm still mute. Okay. Thank you for the question, Rizky. This is an interesting question. However, I would like to answer that by highlighting that the protection of copyright itself, according to the regulations of copyrights in Indonesia, it does not need registration. Therefore, when a content creator has already broadcast the content, it's directly the protection given by to the content. So I think I hope my simple answer can answer your question, Mr. Rizky.
Okay.
Yeah.
Thank you.
So probably it's not, it cannot reduce the violation of copyrights automatically, but the rights of the content creator has been protected through the broadcasting of the content through the social media. So yeah, okay, thank you.
Yes, I would say that yes, it's a big challenge indeed. I would say that currently in the European Union, there is no special regulation for that. So the situation is that cases like that, cases raising this problem, time to time appear, and there is a case-by-case solution for that. So it means that there is an application for the general rules of protection, with taking into account the specific circumstances of the case, that in the social media context, what is the concrete circumstances of violation, and they try to find solution on a case-by-case basis. Starting the finding protection, it begins with the national courts, and it usually can be an issue of EU court interpretation when an EU court in this respect asks a so-called preliminary ruling from the European Court of Justice. So now, currently, according to the current state of EU law, I can give that.
Okay, so thank you very much, Prof. Ildiko. I will then
Excuse
continue.
me, yeah, Miss Dina, since Rizky has given an explanation, more explanation for his question, I would like to add a bit about this. Thank you, Rizky, for giving a more clear questions to. I would like to add. Actually, I would like to answer that by saying that for copyright, there is a fair use doctrine. So other party can use another party's copyright, but when the copyright, the content still in the not all of the creation, and then for probably like in YouTube, I think the YouTube has its policy. When someone use another content, the YouTube will, like a song, the YouTube will silence the song. So we haven't had any regulation, as far as I know, on that, since YouTube has already its policy. So thank you.
Thank you very much, Ms. Ira, for the further explanation. It was really insightful as well. So I will continue to the next question from Prof. Dewi. Prof. Dewi, do you want to directly speak to Prof. Ildiko? Is Prof. Dewi still here?
Yes, thank you, Ms. Dina. Hello, Professor Ildiko.
Hello.
I know my question is asking. I would like to know about resolving intellectual property disputes. I know that you not mentioned it in your paper, but I just want to know how to resolve intellectual property dispute in the European Union. And maybe you can provide an overview. And then intellectual property dispute in European Union, is it in solved with court or outside court? Maybe you can provide an overview about that. Thank you.
Thank you for the questions. Very good question. I would say first giving a very simple answer that mainly by courts, which means mainly by national courts. Why? Because so that there are only limited cases when alternative dispute resolution or something like exist for giving protection of intellectual rights in the EU. So the question why national courts of the member states can give this protection, on the one hand, because of the fact that when it comes to regulation, when an intellectual property rights issue is regulated by the means of so-called regulation of the European Council or the Parliament, in this case, regulation can be applied directly by national authorities as well, and also by national courts as well. It means that almost all the disputes begins on the at the national level, and on the one hand, if the means of EU regulation is directive, in this case, directives must be implemented by national law, and this national law provision will be invoked by the applicants in an intellectual property rights case. And so it means that also because of the fact the EU has also applies in the field of intellectual property rights an approach that in light of the principle of subsidiarity, it is better to leave the enforcement issues to the national courts. Therefore, national courts are the main bodies for solving this kind of disputes. And if the national court has a question of interpretation, then it can go to the European Court of Justice to ask a preliminary ruling from the European Court of Justice, but it is not solving the problem. It is only giving interpretation to the question of the national court. It is also important to emphasize in relation to your question that when it, yes. That when it comes to conflict between competition law and intellectual property rights, in this case, in most cases, the national competition authorities have the competence to solve the problem, and in this case, the national competition authorities' decision can be challenged before the national court as well.
Thank you very much. But I'm wondering about, are there any intellectual property disputes that are resolved outside of court?
No, not really. So mainly the courts are not really in only exceptional cases. For very specific fields of intellectual property, but this is not the general tendency. So the general tendency is that courts, national ordinary courts, are responsible for solving such problems.
Okay, maybe perhaps through an arbitration institution under the European Union?
Yes, but so I would say that this kind of dispute resolution by means of arbitration is now not so frequent. I would say it is rather the case when the European Union concludes an agreement with another country, with a non-EU country. In this, it is a very interesting issue that in this case, it is more often alternative dispute resolution bodies are assigned as being responsible for the dispute resolution than when it comes to an internal matter within the European Union. So, for example, the European Union concluded the free trade agreement with the United Kingdom after the Brexit. And this agreement gives much more opportunity for using alternative dispute resolution for solving cases than when it comes to a case within the EU. What does it mean for intellectual property? It means that, for example, when there is a competition law case which concerns, and it is often the case that it concerns intellectual property rights protection, in this case, when this is a dispute between a British, I don't know, trademark holder and someone who infringes within the European Union, in this case, it is more, it is a preliminary resolution. Resolution form will be an alternative dispute resolution assigned by the free trade agreement, the Brexit free trade agreement. But in the case when not a British trademark holder or violator is concerned, is involved in the case, in this case is rather the in this case, the general rule applies that the courts are the national courts are responsible for solving the issue.
Thank you so much for your explanation. Thank you, Ms. Dina.
Thank you, Prof. Dewi and Prof. Ildiko. Okay, so I will continue to the next question. There's a question from Ms. Desti. Would you like to Ms. Irawati, would you like to directly asking the question, or is Ms. Desti here? Okay, then I will read the question to Ms. Ira. Regarding a trademark you have once quoted, had Indonesia also tried to claim a trademark upon perfumes? So my question, is it merely upon the brand of the perfume, or is it solely to the scent? Recalling that many perfumes, especially made for women, was based on flowers, and hence could this trademark each scent of perfumes with the base of Indonesia's flower, jasmine in example? Thank you very much in advance. Ms. Ira.
Okay, thank you, Ms. Dina. Hi, Desti. I assume that you know me probably. Yeah. So thank you for your question. So Ms. Desti, I think there are some questions here. The first one is that had Indonesia also tried to claim a trademark upon perfumes? So it is I can answer this by quoting from the regulations of Indonesia about trademark. Now, the regulation which is still effective now, I don't think that perfumes has already stated in the regulation about has Indonesia made some attempts to include it. I haven't read about this so far, honestly. Yeah, and then it is interesting because in WIPO itself, I read that the protection for trademark almost limitless. So whatever can be very distinct, unique, or differentiate one probably letters or colors or the combination of those can be used as trademark. However, in Indonesia, there is a stipulation in the job creation law. It limits actually on what kind of things can be used as a trademark. It is a functional type of a thing. It can not be registered under trademark. I suspect because we have design, industrial design. So it should be falls into the industrial design type. So another question, is it solely to the scent? Yes, it's not the brand of a perfume. So the scent, which is distinct, unique, and of course has not been registered by another party. But I would like to remind again, it's not implemented because it hasn't been regulated in Indonesia yet. So about the scent, about the flower, it could be, but it should be very distinct and has not been registered by another party. So thank you. Have a lovely day to you too, Desti. Thank you, Ms. Dina.
Thank you, Ms. Ira, for the answer. I will continue to the next question from Ms. Rindia. Is Ms. Rindia still here? Do you want to directly answer the question? Asking the question to Prof. Ildiko. Ms. Rindia. Okay, so I will read the question. So from Ms. Rindia to Prof. Ildiko. In Indonesia, the main requirement for patent registration is novelty. In the European Union, how do you determine whether a registered patent contains novelty? Thank you.
So in this case, yes, the novelty is also the main requirements in the European Union as well. The European Union general patent rules are not so specific in this respect, but they rather refer to the European Patent Convention, and there is also a specific regulation for biopatents, and in this case, it is also so it is also not a detailed description of the new or the novelty concept. The only requirement is that there must be some innovation in the patent, but this is so not so. I would say that it's not so specific like the European Patent Convention. That's the reason.
Okay, so thank you very much, Prof. Ildiko. So there is, I think, the last question from Ms. Suci. Prof. Ildiko, are there any examples related to the point of C, applying different conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage in EU competition law, Article 102 TFEU?
Yes, so it mainly means it is quite not so frequently applied type of violation of EU competition law, but there are examples that we can mention. It is simply the case when there is a trading party, market actor who is in a dominant position, who is a strong market player, and for example applies different prices with the trading partners. So for example, different selling prices against those who would like to buy from its products, or or services. So when we would like to place it in intellectual property rights context, we can say that if this party don't want to completely deny the access to the intellectual property, but for example, it sells the intellectual property rights with different prices to the trading partners. So one trading partners can get it for cheaper price than the other. In this case, it's a violation of that cited provisions of the TFEU.
Cool. So thank you very much for all of the questions and answer from both Professor Ildiko and also Ms. Ira. I think there's no more questions asked. So okay, so Professor Ildiko mentioned that if anyone wants to have another questions to Prof. Ildiko directly, I will give the email later on to the participants beside the presentation as well. So I think this is the end of the question and answer session. Thank you very much, everyone. This is an interesting session where everyone can ask, and Professor Ildiko and also Ms. Ira already answer based on their expertise. I hope everyone enjoyed the session and can take the key learnings from every speaker. So once again, thank you very much, Professor Ildiko and Ms. Irawati, for the amazing sessions. And thank you, everyone, for your attention. I will close the session and I will give back the session to the MC. Thank you. Thank you, Professor, and thank you, Ms. Ira, as well. So for MC, the time is yours.
Thank you so much. Wow, it's such an interesting discussion. Yeah. Thank you so much, Mrs. Tina, as a moderator, and also our speakers today with her wonderful presentation. Well, ladies and gentlemen, finally, we come to the last section. Now we have to come to the end of this global classroom between Faculty of Law, University of Semarang and Faculty of Law, University of Debrecen, with its intellectual property policy and its implementation in European Union and in Indonesia. I hope the knowledge that we got now can be useful in the future. Feiruz Pramita Alamsyah, as the Master of Ceremony in this event, I'd like to say thank you so much to all the audience who has made this event successful. In the last word, I'm sorry for some mistakes. See you on the next global class. Assalamualaikum warahmatullahi wabarakatuh.
Thank you very much once again, Professor Ildiko. I hope we can meet in the next occasion. Thank you very much as well for Ms. Ira.
Thank you so much.
Thank you.
Thank you very much. Thank you very much. I'm very happy to share my thoughts.
Yeah, looking forward to see you, Professor Ildiko.
I also hope to see you soon.
Thank you.
Thank you.
And thank
Bye.
you so much for the audience.
Thank you for all.
Bye.
Bye.